One wrong sentence cost my client $1.5 million. As a business contract litigator, I've seen brilliant entrepreneurs lose everything to these devastating contract mistakes. Watch now. The third mistake happens in 89% of business contracts. Contracts are the backbone of every business. They define relationships, obligations, and the expectations that keep deals moving forward. But what happens when a contract contains a critical mistake? The consequences can be devastating, leading to disputes, financial losses, and even the total collapse of a business relationship. Today, we're going to break down 5 critical contract law mistakes that can ruin your business, and more importantly, how to avoid them. Let's start with one of the biggest sources of contract disputes: mistakes in the contract itself. Contracts should be clear, precise, and carefully reviewed, yet many businesses fall into traps that can make their agreements void or unenforceable. Mistake number 1, mutual mistakes that make a contract void. A mutual mistake occurs when both parties misunderstand a fundamental fact of the agreement. This isn't just a minor wording issue, it goes to the core of what both parties thought they were agreeing to. In Florida contract law, a mutual mistake can make a contract void because there was never a true meeting of the minds. Let's say a supplier agrees to sell a business a batch of specialized equipment. Both parties believe the equipment meets industry standards, but later they discover that it doesn't. If the misunderstanding was mutual and material, the contract could be voided entirely, leaving both parties scrambling to renegotiate terms, or worse, deal with litigation. To avoid mutual mistakes, always conduct thorough due diligence. Make sure both parties clearly define all terms and expectations before signing. Clarity in written contract is your best protection. Mistake number 2, unilateral mistakes that could cost you. A unilateral mistake happens when only one party is mistaken about an essential part of the contract. Unlike mutual mistakes, unilateral mistakes typically don't render a contract void unless the other party knew or should have known about the mistake and took advantage of it. Here's an example. A company mistakenly types the wrong price in the contract, offering services at half the intended cost. If the other party was aware of the mistake but still signed the contract without pointing it out, the business might be able to seek reformation or rescission of the contract. However, if the mistake was simply a miscalculation that wasn't caught, the business could be stuck with an unfavorable agreement. Prevention starts with careful contract drafting and review. Before signing anything, double-check key terms like pricing, dates, and obligations. Having a second set of eyes, preferably a contract attorney, to review agreements can prevent costly mistakes. Mistake number 3, drafting errors that lead to contract reformation. Sometimes a contract contains errors that don't void the entire agreement, but do create serious misunderstandings. In these cases, courts may allow for contract reformation, a legal remedy that corrects the mistake while keeping the agreement intact. Let's say a construction contract mistakenly includes the wrong completion date due to a clerical error. The parties didn't intend to have an unrealistic deadline, and both agree that the contract doesn't reflect their true intentions. In this situation, a court could order the contract to be reformed to reflect what the parties actually agreed upon. To avoid needing contract reformation, make sure contracts are reviewed thoroughly before they're signed. Use plain language and define all critical terms so there's no room for misinterpretation. Mistake number 4, rescission risks from ambiguous terms. Contracts should be as specific as possible. Ambiguity opens the door for disputes and in some cases can result in rescission, which is when a contract is legally canceled and both parties are returned to their original positions before the contract was made. For example, if a service contract states, deliverables will be provided within a reasonable time frame. What does reasonable mean? One party might think that means 2 weeks, while the other assumes 2 months. If an ambiguous contract leads to a dispute, a court might rule that the contract is unenforceable, allowing one party to rescind the agreement altogether. To avoid rescission due to ambiguous terms, define everything clearly. Dates, deliverables, payment schedules. Every term should be as precise as possible to avoid conflicting interpretations. Mistake number 5, failure to understand remedy limitations. Many business owners assume that if a contract is breached, they can automatically sue for full damages, but that's not always the case. Contracts often contain remedy limitations which restrict what can be recovered in the event of a breach. For instance, a software development contract might include a clause stating that in the event of non-performance, the only available remedy is a refund of payments made rather than additional damages for lost business. If a business doesn't understand these limitations before signing, they can find themselves with little recourse if things go wrong. Always review the remedy clauses in your contracts carefully. If you're not comfortable with the limitations, negotiate better terms before signing. Once an agreement is in place, courts will typically enforce it as written. Contract mistakes happen, but they don't have to be business-ending disasters. By understanding mutual and unilateral mistakes, preventing the need for reformation or rescission, and carefully reviewing remedy limitations, you can safeguard your business from costly legal battles. Before signing any contract, take the time to review it thoroughly. If there's any uncertainty, seek legal counsel. A well-drafted contract isn't just a piece of paper, it's a business asset that protects your interests and ensures smooth transactions. At the end of the day, the key to contract law success is clarity. Clearer terms, clear communication, and clear expectations prevent disputes and keep your business moving forward. Protect your agreement and protect your business. Thanks for tuning in, and if you have any questions about this or other legal topics, drop them in the comments below. Don't forget to like, subscribe, and share this video if you found it helpful. Until next time, stay informed and stay protected.